It has now been 1 year since the European Union's General Data Protection Regulation, known as the GDPR, has become applicable. While criticism of the GDPR still is voiced in certain circles, for example, the perceived incompatibility of certain of its requirements, such as purpose limitation, in the context of particular big data uses, and freedom of expression concerns with respect to the right to be forgotten. The focus of U.S. tech giants' corporate political activity has shifted mainly to the United States, where there is a discussion of a potential federal privacy law in the United States. Awareness raising has gone on during the last year, and complaints of GDPR violations increased compared to those under the previous law. For example, the French CNIL registered a 32.5% increase in complaints in the last year over 2017. Meanwhile, the privacy profession has boomed, with an estimated 500,000 data protection officers, or DPOs, having been registered throughout Europe. This is an IAPP estimate. DPOs are required for many companies under the GDPR. Many international companies have also been working over the last year to adjust their procedures to comply with the GDPR, although sometimes with varying interpretation of the provisions of the GDPR. Administrative fines for companies may, at the most serious level of violations, go up to a maximum of 20 million euros, or 4% of annual global turnover, whichever is greater. The tech giants, in this context, may see maximum fines in the billions of euros, in addition to other sanctions, such as orders to halt data processing. While the fines issued during the GDPR's first year have been much less than such maximum amounts. For example, Google was fined 50 million euros by the French CNIL, far below the maximum of approximately 3 billion euros. Data protection authorities, such as that of Ireland, have warned of fines to come being substantial. That we haven't seen more large fines to date is due in part to the GDPR fines only applying to data protection violations since May 25, 2018, and the fact that it takes time to conduct these violation investigations. The degree of compliance with the GDPR may also be seen as an element of legal strategy. Already, U.S. companies have been seen to have different compliance strategies. While some companies, such as media outlets, have sought to avoid the GDPR by blocking potential EU users, the tech giants have generally either sought a minimal level of compliance with the regulation or have chosen to take a more strategic approach to the GDPR by embracing compliance and, for example, offering GDPR-like protections to their consumers worldwide. This latter strategy may have advantages in terms of efficiencies in streamlining procedures for all customers and as preparation for legal developments worldwide, as the GDPR more and more influences laws in countries and states outside the European Union, including, for example, California. The result may also be greater consumer trust. A further measure could involve combining the roles of the required DPO with existing chief privacy officers and making the resulting officer responsible for worldwide data protection law compliance. At the base of such actions would be the adoption of the European Union's definition of the kinds of data that are subject to protection. Its definition of personal data, which is the broad categorization of data that is included in cross-border data transfer mechanisms like the Privacy Shield, like binding corporate rules, and which is something which companies must first understand. My study, co-written with Kim Hauser, Personal Data and the GDPR, providing a competitive advantage for U.S. companies, should help.